Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
The intersection of lien resolution and settlement planning is not always clear. The most important thing to understand is that reduction of a lien provides an opportunity to discuss settlement planning options with the injured party. There are also specific liens that should trigger a planning discussion in every case. Critical planning discussions not only protect the injured party, but allow a plaintiff attorney to avoid any malpractice liability. In this webinar, we will review the most common types of liens and the settlement planning considerations associated with them. The goal is to use the lien resolution process as a driver to determine what planning discussions to have with the injured party, including set-aside arrangements, public benefit preservations, or financial settlement options. The presenters today are Teresa Kenyon, the Director of Lien Resolution Services at Synergy, and Samantha Webster, Synergy's Director of Case Management in the Settlement Planning Department. Teresa is a licensed attorney in California and Kentucky. Prior to joining Synergy, Teresa spent almost 8 years with the Rawlings Group, the largest insurance claims recovery company in the industry. Teresa and her team provide invaluable assistance to plaintiffs' attorneys by handling all types of healthcare liens and bringing them to swift resolution. Samantha is a licensed insurance agent in multiple states and spent more than 10 years working for plaintiff personal injury firms. She worked in various roles, including filing Social Security disability claims for the disabled and drafting pre-suit demands. At Synergy, she manages the settlement planning staff, assists with the general agency, and discusses settlement planning options, including referrals for other services such as Medicare set-asides, trusts, and professional administration of MSAs. In this webinar, we will discuss various lien types, including Medicare, Medicaid, ERISA, and hospital liens. Our discussion will include an explanation of each lien type and important facts regarding the negotiation of the lien. For each lien type, we will then review the settlement planning implications and options available to the injured party.
So let's go ahead and jump right into it. This is Teresa Kenyon, the Director of Lien Resolution here at Synergy. We are going to start the discussion with what options might be available after you obtain a Medicare final demand. So let's talk about a particular case that Synergy handled for Eloise. Eloise had a slip and fall in a store, and her attorney was able to secure her a $500,000 settlement. Her injuries included a broken hip, broken wrist, both of which required surgery and long-term treatment in a rehab facility, and Eloise was a Medicare beneficiary. So what action steps should be taken when an injured party is a Medicare beneficiary? Well, the first thing that you want to make sure that you're doing is reporting the pursuit of the third-party liability case to Medicare. The Benefits Coordination and Recovery Center, otherwise known as the BCRC, is responsible for ensuring that Medicare gets repaid for any conditional payments it makes. A conditional payment is a payment that Medicare makes for services that another payer may be responsible for. Medicare makes this conditional payment so that the beneficiary doesn't have to use their own money to pay for the bill at the time of service. And instead, the payment is considered conditional because it needs to be repaid to Medicare once there is a settlement or a judgment, an award, some other kind of payment from another responsible party. So what else do you want to be doing? You want to make sure you are auditing and disputing the conditional payments for relatedness. The billing codes sometimes have issues, so you want to make sure you're performing your own due diligence and reviewing the claims and making sure that only claims that should be part of the case are actually part of the conditional payment. Then, once the case settles, you need to submit the settlement information, including your fees and costs. And this is because Medicare will apply a procurement cost reduction or reduce the amount to be repaid by an amount equivalent to your fee and cost percentage. If the settlement is limited, then they'll allow your fees and costs to come off the top with the remaining amount to be paid back to Medicare for their conditional payment. And then after that information is submitted, Medicare will issue the final demand, which is the reduced amount. So in this case for Eloise, the conditional payment was about $148,000. Synergy did submit disputes and they were favorable. So after Synergy did its work, the reduced conditional payment amount was about $42,000. After submitting the procurement cost, the final demand was issued and it was about $25,000. So in this particular case, the total savings from what could have been payments towards a lien were about $123,000. Now in this case, there was also a future medical possibility for a surgery that was estimated to be $50,000. And so we want to look at the whole picture. We want to take a look at what kind of options are here for future settlement planning for Eloise. And for that, I'm going to pass it over to Sam.
When a Medicare lien exists, the settlement planning considerations will depend on whether the injured party will need future injury-related care, and an MSA allocation has been done. An allocation will provide a figure that will need to be set aside to pay for the future injury-related care that would otherwise be paid for by Medicare. The report should also identify the options for funding the MSA. The two choices are a lump sum funding and using a structured settlement arrangement. The choice between the two options is up to the parties settling the case. The final planning consideration for an MSA would be the administration of the account. Who handles the administration of the MSA may be a decision made at time of settlement by either the injured party or defense. For a Medicare beneficiary that settles a claim and will need future injury-related care, Medicare's interest should be protected. The preferred method to protect Medicare's interest is a use of a Medicare set-aside, or MSA. The question often arises about who is considered Medicare eligible and would need an MSA. CMS guidelines discuss those currently eligible and those with a reasonable expectation of eligibility. The definition of reasonable expectation is enrollment within 30 months. To meet this threshold, a claimant must have applied for Social Security disability benefits, been denied and expect to appeal the decision, is in the process of appeal or reapplying, or approaching Social Security retirement age. All of these could trigger a Medicare entitlement in 30 months. Once a decision is made that an allocation is necessary, an MSA allocator will evaluate the annual injury-related medical expenses normally covered by Medicare, add the annual prescription expenses normally covered by Medicare, and calculate the sum of those items over the claimant's remaining life expectancy. The end result is the Medicare set-aside allocation. Once the allocation is complete, the report should identify the options for funding the MSA. The two options are a single lump sum or a structured settlement annuity arrangement. A single lump sum is just the full amount of the allocation set aside, and this would reduce the settlement proceeds by that specific amount. With a structured settlement annuity, the funding of the MSA is broken down into two parts. An initial seed amount is used to establish the MSA account, and then a structured settlement annuity is used to make annual payments to replenish the MSA. The duration of the annual payments is based on the claimant's remaining life expectancy as outlined in the allocation report. This option can provide cost savings to the claimant, as the settlement proceeds would be reduced by the initial seed and just the cost to fund the structured settlement annuity versus the full amount of the allocation. This is a page from the MSA Allocation Report for our example for Eloise. In the middle, you see Medicare covered expenses, and there are line items for future medical items or services, future surgical items or procedures, and future prescription medication. The total proposed Medicare set-aside allocation amount for LOEs is $93,664. This is the amount that LOEs would need to deposit into her dedicated MSA account if she chose to fund it with a lump sum. So to review, if the MSA is funded with the full amount indicated on the allocation report or CMS approval, the settlement proceeds are going to be reduced by that full amount. And for this, the full amount must be depleted before Medicare will resume any payment for future injury-related care. In lieu of a lump sum funding, the Medicare beneficiary may choose to fund their MSA with a structured settlement. Using a structured settlement to fund the MSA reduces the amount of settlement proceeds needed to fund. The MSA starts with an initial deposit, which is indicated on the allocation report or CMS approval. And then beginning in 1 year, annual payments from a structured settlement are made to replenish the MSA account. The duration of the annual payments is tied to the life expectancy of the Medicare beneficiary. With a structured settlement arrangement, the annual payments plus any accumulation from past years must be spent down before Medicare will resume payment for future injury-related care. Returning to the example involving LOEs, we can see that our Medicare set-aside allocation report identifies structured settlement parameters. LOEs would need to seed or provide an initial deposit into her MSA account of $17,029, followed by annual payments of $7,663 for 10 years. This arrangement would be done through a structured settlement, and there are several options that can be used to meet this requirement. Let's take a look at a couple of examples. In this example, we can see that the MSA seed or initial deposit is represented as an upfront cash item to LOEs. This amount would be placed in her interest-bearing MSA account and would establish the account. In the following year, annual payments would be made to replenish the MSA. In this example, the payments are made under a temporary life annuity. A temporary life annuity provides the annual payments as long as Eloise is living for a maximum of 10 years. When you compare this option to funding the MSA with a lump sum, there is considerable savings. To fund with a lump sum, Eloise would need to take $93,664 of her settlement proceeds to fund the MSA. But in this example, between the seed and the cost of the annuity, the amount needed to fund is only $82,962. An alternative to the temporary life annuity is a period certain annuity. A period certain annuity would provide annual payments to LOEs for the same duration as a temporary life annuity, but instead of the payments only available if Eloise is living, the payments under a period certain annuity are guaranteed. So in this example, you can see that the MSA seed or initial deposit is still reflected as an upfront cash item to LOEs. The annual payments under the period certain annuity are for the same 10-year duration, but are guaranteed payable in the event of Eloise's death. If Eloise dies any time in the 10-year duration, any remaining payments would go to her designated beneficiaries. Again, the settlement option using a period certain annuity provides cost savings for LOEs. In lieu of $93,000 needed to fund the MSA, this option would only require her settlement be reduced by $88,993. Although both structured settlement annuity options provide cost savings to LOEs, we should take a look at how they impact her overall settlement. For LOEs, her total settlement of $500,000 would first be reduced by her attorney's fees and costs. For the MSA, we can compare the two structured settlement annuity options side by side. Option A, the temporary life annuity option, would require the initial seed amount and an annuity cost of $65,933. Assuming no other line items on her distribution or closing statement, the net proceeds to LOEs would be just over $291,000. For option B, the period certain annuity, the same line items exist, but the MSA annuity cost is slightly higher. LOEs is still realizing cost savings over the lump sum funding option, but the additional cost to guarantee her annuity payments will reduce the final net proceeds to her to just over $285,000. In our example, the difference between the two is just over $6,000. While we can compare the two structured settlement annuity options side by side and realize the cost savings, let's take a look at how they compare to the funding with a lump sum. When we compare to the lump sum funding option, we can see the true impact of using a structured settlement annuity to fund the MSA. The temporary life annuity option would provide over $10,000 additional money in Eloise's pocket compared to the lump sum. For the period certain option, the savings are not as great, but would still provide over $4,600 in additional proceeds. Again, while cost savings can be a significant factor driving the decision, and an important one for the injured party, it is not the only consideration. The size of the MSA and the amount of the settlement also play a role. Ultimately, the choice between the options should be discussed and agreed to by the parties settling the case. The final settlement planning consideration when Medicare is involved and an MSA is being done is the administration of the account. The two choices are self-administration or professional administration. Self-administration would be handled by the injured party. Professional administration can be provided by a neutral third-party administrator or through a trustee within a trust subaccount. To understand the difference, it is important to understand what each entails. For self-administration, the burden of administering the account falls on the injured party. The injured party must set up a separate interest-bearing account to house the MSA funds and notify their healthcare providers that billing for injury-related care will be done through the MSA arrangement. The injured party must pay their bills for injury-related care from the account, keep complete records, prepare and send annual attestations to Medicare, and send a final attestation to Medicare when the account is exhausted. The benefit of professional administration is that another is responsible for all the items required in the self-administration column, but with added benefits to the injured party. Most professional administration will also review bills for accuracy, apply discounts, and provide an advocate team to assist the injured party in finding doctors for care and pharmacies to fill prescriptions. While a neutral third-party administration company may be used by an injured party, an MSA can also be professionally administered within a trust. The third party only offers a custodial arrangement which may put the injured party's money at risk in the event of insolvency of the administrator. A trust, however, creates a fiduciary duty on the part of the trustee of the trust. This means it can go in perpetuity even in the event the trustee can no longer serve and a new one is appointed. Pooled trusts give the trust beneficiary an experienced set-aside administrator who can adjudicate bills and manage the intricacies of reporting to Medicare, along with being a corporate fiduciary.
So let's now turn to Medicaid liens. We just talked about Medicare and what could happen if there's a Medicare lien and the options that are available for settlement planning. Let's go to Medicaid now. Just some facts about Medicaid. Medicaid is a jointly funded state and federal program that is providing health benefits to low-income families and individuals. There's a high proportion of enrollees that are either children or the elderly, and there are often seniors that are in long-term care facilities. Estimates vary, but about 65% of nursing home residents are on Medicaid coverage. So every Medicaid program is actually required by federal law to have a third-party liability recovery scheme in it. Both state and federal law are applicable to Medicaid liens. It definitely creates some gray space when we are negotiating these liens here at Synergy. But Medicaid, similar to Medicare, is considered a payer of last resort. And Medicaid can pursue all of the different sources of recovery. So they can look at PIP or MedPay or no-fault coverage. They can look at or UIM settlements, the liability settlements through bodily injury, and even other government-sponsored programs for reimbursement purposes. There are two main U.S. Supreme Court cases that can definitely assist with your negotiations of these liens. So the first one is the Allborn case from 2006, and it essentially said that the federal Medicaid anti-lien provision limited Medicaid's lien to only those settlement funds that could be attributable to past medical expenses, not future medical expenses. So many states have statutes that are incompatible at this point with the Allborn holding, but they continue to enforce them as they are written. Virginia and South Carolina would be two examples of that. Ultimately, if the two sides can't agree to an allocation under the Allborn case, what the allocation should be, then a hearing is required to allocate settlement funds. In Florida, Conduent is a large proponent of forcing things to a hearing for this very purpose. The other case that's important as it relates to Medicaid is the WAS case from 2016, and it essentially said that statutes that contain arbitrary allocation schemes also violate the anti-lien provision, and it reiterated that if no agreement could be reached between the agency and the beneficiary as to how the settlement fund should be allocated among all of the damages, then a hearing would be required. So here is another sample case of a lien that Synergy handled. So Sunshine Health had a lien that was being handled by the Rawlings Company as its subrogation vendor. The lien amount was $177,000. This particular case settled for $1.25 million, and ultimately this lien was reduced to $100,000 using the Allborn case, getting some resistance from the Rawlings Company as it related to the allocation, but ultimately we were able to negotiate this amount, which had lien savings of $77,000. So in that case, there are settlement planning options, because now it's not just the settlement amount minus the attorney's fees and costs minus the full lien amount that now gets to be considered for the injured party. There's now more. There's now $77,000 more in the pot that should be considered. So we're going to go back to Sam.
For the injured party in our example, the Medicaid coverage was essential to keep as it was his only source of medical coverage. Although the lien savings of $77,000 plus any other proceeds from the settlement would provide a source of funds to either cover medical treatment or to potentially purchase other coverage, the injured party wanted to keep the Medicaid coverage. Using lien savings to cover the expenses from the loss of Medicaid may not be in the injured party's best interest, so it's essential for them to understand that there is a solution. For an injured party receiving Medicaid or other needs-based benefits, the most important settlement planning consideration may be the preservation of those benefits. If the injured party receives their settlement proceeds in a lump sum of cash, they must understand that those benefits may be terminated. If the benefits are supplemental security income, or SSI, through the Social Security Administration and associated Medicaid coverage, the injured party may risk not only a source of income, but their source of medical coverage. For those that do not want to risk losing benefits, a special needs trust is the best option. There are several types of trusts available, including standalone special needs trusts and pooled special needs trusts. The primary difference is a standalone special needs trust is specific to the individual and therefore comprehensive and customized. In contrast, a pooled special needs trust involves a number of trust beneficiaries whose resources are pooled, with each trust beneficiary having their own subaccount. This pooling of resources allows a pooled special needs trust to be more cost-effective than a standalone trust. With benefits that are income and asset sensitive, it is important to have an injured party consult with someone to discuss the options. While the loss of SSI may generally be acceptable by the injured party settling their case, the loss of Medicaid may be devastating. Having a discussion with the injured party before settlement about the options available is essential. For an injured party receiving government assistance or needs-based benefits, there are a number of advantages to utilizing some form of a trust, including preserving entitlement to those needs-based benefits, providing a lifetime of financial support and medical care, supplementing what public benefits do not provide for, creating a system of advocacy to protect a client's quality of life, and establishing a long-term framework for management of the recovery. There are a number of special needs trust options available, and understanding the one that is right for the injured party should involve a consultation with an expert. The type of trust needed, the advantages and disadvantages of the trust, and making sure that the injured party understands the obligations of the trustee are all very important considerations. The primary types of special needs trusts for personal injury settlements are the standalone trust for those disabled under the age of 65, a pooled special needs trust for those disabled at any age, and third-party trusts. The advantages of any special needs trust are the retention of SSI and Medicaid benefits, the professional trustee, the potential to avoid guardianship and annual reports, and the settlement proceeds in the trust being available to pay for everything except food and shelter. There are some disadvantages, though, that the injured party should discuss with an expert and fully understand. The primary is that the special needs trust does not provide unrestricted use. Other disadvantages are the payments or distributions from the trust must be for the sole benefit of the trust beneficiary, and upon death, Medicaid must be paid back with the standalone or the pooled special needs trust. The trust is also irrevocable, and since the funds in the trust are handled by the trustee and not directly by the injured party, there can be an extra layer of complexity involved when funds are needed. One final consideration is a dual eligible injured party, specifically what should be done for an injured party that is eligible for both Medicare and Medicaid. Some low-income Medicare beneficiaries are also qualified for Medicaid, with Medicaid paying for items that may not be covered by Medicare. Since losing Medicaid may have devastating consequences for the injured party, it is important to also connect a dual eligible injured party with an expert to discuss how to preserve the Medicaid coverage using a special needs trust.
And let's talk about ERISA liens now. So ERISA liens also can be reduced, even though they often act like they cannot be reduced. But let's take a look at a sample here shortly. So first, you want to determine if it is an ERISA plan. And basically, ERISA plans are employer-sponsored plans. And really, it's all employer plans, but there are some exceptions. So religious employers aren't covered under ERISA. Those are subject to state law versus federal law, which most of these like ERISA plans are going to fall under. And then also government employers. These are going to be subject to either state or a different federal law than ERISA. So just city, county, state, and federal employees would not constitute an ERISA plan. ERISA also doesn't govern Medicare plans, Medicaid plans, or military plans. So any of the government type of plans would not be considered ERISA. And then it also wouldn't cover individual plans. So plans that were purchased for just one person. This would be oftentimes when people are self-employed, they'll use an insurance broker or purchases made through the marketplace because of the Affordable Care Act, the Obamacare. Those are not covered by ERISA either. So the most important question to ask on an ERISA plan is it self-funded or is it fully insured? And it's an important question, but it can have a confusing answer, and it can be confusing to even get to the answer. So the reason why it's important is that for these self-funded plans, they do preempt state law. So what does it mean to be self-funded? It's essentially looks the same. It looks the same as a fully insured plan. In both situations, the employer collects a premium, let's just say $100 per pay period for the privilege of having health insurance through your employer. But the difference is where that money then goes. For a self-funded plan, the employer collects it and puts it in their own bank account that's just for this purpose, for paying the health insurance claims, the actual medical benefits. Whereas a fully insured plan will take those premiums and then pay the insurance carrier, pay Cigna, pay United, pay Aetna, a premium, where then the financial burden is on that insurance carrier to pay for those claims. Whereas the self-funded plan has to pay for them themselves. The confusing part is that United, Cigna, Aetna are involved in both situations because they are both collecting the bills, processing the bills, and paying the bills according to the contractual rates that they have. But it comes down to where the money's coming from. Is it coming from the larger risk pool in the fully insured case, or is it coming from the very specific employer-based health pot in the self-funded case? So let's look at a case that Synergy handled. So we had a medical malpractice claim that had to deal with a misdiagnosis of a stroke in the ER, and the injured party was now permanently paralyzed. There was a $629,000 ERISA self-funded claim being asserted by Optum. Ultimately, this case settled with caps for $1.55 million. And Synergy argued that there were policy language deficiencies, that the self-funded plan wasn't strongly worded enough to be able to collect for the $629,000 that they were looking to collect. So ultimately, our specialist was able to get it reduced to $85,000. This amounted to lien savings of $544,000 that now the injured party had to consider. What am I going to do now with these additional settlement funds, these additional lien savings that I now have? And for that, we will go back to Sam.
It is never too early to discuss settlement planning, and it is never too late to discuss settlement planning. Ideally, settlement planning discussions occur before final settlement is reached and before the lien is resolved. When lien savings are realized, it offers an additional opportunity for the injured party. Discussing planning option after the lien is resolved and the savings are realized is possible even if the injured party did not choose an option for their other settlement proceeds. While a structured settlement can be used in nearly any personal injury settlement, we're going to identify options for the savings realized from lien reductions. In this section, we will focus on ERISA liens. For example, the injured party had savings of over $544,000. What option to use depends on whether the settlement proceeds have already been released by the defendant or insurer and what are the injured party's future needs. The reduction of an ERISA lien, or any lien for that matter, can provide unexpected additional proceeds to the injured party. The injured party can choose to receive the amount in a lump sum or in periodic payments. By receiving periodic payments in lieu of the lump sum, the injured party has an opportunity to use the lien savings to plan for their future after settlement. The injured party can choose to defer payments, receive the payments over a duration of time, or specify a lump sum payment in the future to cover various needs. Among the options available to the injured party are a traditional fixed structured settlement, a single premium immediate annuity, or a fixed indexed annuity. The most important factor in determining which option is available for an injured party is who has possession of the settlement proceeds. The ability to use a traditional fixed structured settlement requires the proceeds to be in the defendant or the insurer's possession. If the settlement proceeds are in the possession of the injured party or their attorney, constructive receipt has occurred. Constructive receipt of the settlement proceeds does not eliminate the option for future payments, but it does limit the type of option available. With constructive receipt, the injured party may be limited to a single premium immediate annuity or a fixed indexed annuity. These two options are not income tax free, but become tax deferred. For any settlement, it is important to understand that not every penny of proceeds must be planned for. The injured party has the option to take a portion of their settlement in a lump sum and a portion in one of the other settlement alternatives available. The options available to an injured party are infinite. The injured party, in most cases, can determine the schedule of payments, including the start date, duration, amount, and frequency. In some cases, the decision to structure is dictated by need and the payment schedule or payment stream is set to cover specific items such as attendant care, income replacement, expenses not covered by insurance, or even future needs such as retirement or college expenses for children. The needs of the injured party are as infinite as the options. An expert planner can help an injured party determine which option is right for them and provide proposals for their consideration. In addition to the consultations, an expert planner can perform financial needs analysis as well as economic or life care plan analysis to help. Before we leave the topic of tax-free structured settlements, it is important to know some of the essentials needed for them. For a tax-free structured settlement, the defendant or insurer must fund the structured settlement annuity directly. The defendant or insurer must agree to a qualified assignment unless they intend on owning the annuity contract. The defendant or insurer must agree to a release containing necessary language regarding the structured settlement. And finally, cases involving court approval must indicate a structured settlement will be utilized, including a detail of the terms. When a tax-free structured settlement is not an option, perhaps in the case of constructive receipt of the proceeds, the injured party still has an opportunity to receive periodic payments. The alternatives are a single premium immediate annuity or a fixed indexed annuity. For a single premium immediate annuity, the annuity can be purchased from funds in the possession of the injured party or their attorney. Payments are not income tax free, but considered tax deferred. In each year, the taxable portion of the payments received is reported to the injured party to pay tax. Each payment under a single premium immediate annuity consists of a taxable amount and a return of the portion of the purchase payment. The exclusion ratio represents the portion that is not subject to taxes. Finally, for a single premium immediate annuity, the payment options have limitations. The payments must comply with IRC 72U or 72Q. These sections of the IRS code require payments to be substantially equal, commencing in 1 year of purchase, and the owner and payee must be natural people. Unlike a traditional structured settlement, which has nearly infinite options, a single premium immediate annuity does not, and it may not be suited for certain settlements such as minors or those needing deferred payments. For most personal injury settlements, the preferred option is the tax-free structured settlement. For an injured party who is not worried about losing the tax-free payments available in a structured settlement and is looking for more flexibility than a single premium immediate annuity, a fixed indexed annuity may be an option. A fixed indexed annuity provides full protection of the principal with potential for growth linked to the performance of a market index. This type of annuity provides long-term security with the flexibility for growth and customized income options. The principal investment is protected from any downside risk. The value can only go up, but never go down. Interest credited in any given year can only be positive or zero. The fixed indexed annuity also provides triple the benefit of tax deferral, with interest on the premium, interest on the interest that is credited, and interest on tax savings. The fixed indexed annuity also offers additional benefits to the injured party. A fixed indexed annuity has liquidity, as the injured party may withdraw up to 10% of the contract value annually without incurring a withdrawal charge. There is also a death benefit protection. If the owner dies, the full accumulation value is paid directly to the beneficiary, thus avoiding probate. There may be a nursing home waiver and terminal illness waiver for additional protection, and there are no management fees or commissions paid by the owner.
And finally, let's talk about hospital liens. So we've talked about health insurance liens, but if you don't have health insurance and you still need medical treatment, then the hospital can assert a lien against your settlement, just the same as the others. It's actually a little bit different than the others because most states have statutes. It could be a state statute, it could be a county ordinance, or it could even be a contractual lien that the hospital or provider has. 40 states and the District of Columbia have enacted state hospital lien statutes. And here's just a listing of where all those statutes can be found. So when a hospital has a bill, we call it the full bill charges. This is just an example of a hospital bill with a full bill charge of $95,000. There is a reasonable value of those charges, and this is something that Synergy is able to do. We have a specialized analysis to determine what that reasonable value is by looking at the billing codes. And in this particular case, with this $95,000 bill that we had, the reasonable value was $20,000. Now, normally the way that things are negotiated is that you take the $95,000 and you put a discount on it. You put a reduction, 20%, 30%, 40%. And we've got some numbers here, but obviously you can see that what that is a lot of profit for these hospitals, because those full bill charges are just made up numbers that are very inflated. So what Synergy often does in these reasonable value cases is an inverted negotiation. So instead of going from the top down, we go from the bottom up. So if the reasonable value is $20,000, then we will offer you 25% more than the reasonable value as the hospital with your inflated bill charge. And that means a $25,000 payment to you. And ultimately it's a 74% reduction from the full bill charges of $95,000. So this is just some math on how it is that we approach these.
As is the case with ERISA lien savings, hospital lien savings can allow the injured party the opportunity to plan for their future. The same options of a traditional fixed structured settlement, a single premium immediate annuity, or fixed indexed annuity are possible. Again, the primary consideration is the possession of the settlement proceeds. Constructive receipt may impact the options available, and it is always best to consult with an expert settlement planner as soon as possible. If the injured party intends on using a planning option, the settlement planner can help guide the process and make sure that all the available options are discussed. One final point that must be made is that settlement planning considerations are often combined to provide the injured party the best outcome and plan for their future. As we discussed earlier in this webinar, a structured settlement can be used to fund a Medicare set-aside to provide cost savings. With a pooled special needs trust, a structured settlement can be used to provide the injured party a steady replenishment of funds to the trust. An injured party that is dual eligible, meaning a recipient of both Medicare and Medicaid, may use a combination of a pooled special needs trust, a structured settlement, and a Medicare set-aside. The structured settlement can be used to fund the MSA and the trust, with the MSA being administered within the special needs trust. A fixed indexed annuity can also be paired with either a structured settlement or a pooled special needs trust, or both. The combination can provide a very comprehensive long-term plan for the injured party. It is important to consider the settlement planning options when there is a lien for an injured party. Knowing what discussions should be triggered depending on the type of lien is key. Medicare, Medicaid, ERISA, and hospital liens can provide direction to the type of settlement planning discussion. When there are multiple lien types for the same individual, it may be necessary to consider combining settlement planning options to plan for their future. During our webinar, we discussed that it is essential for an injured party on Medicare to understand when and how to protect Medicare's interests when settling their personal injury claim. We also discussed that an injured party must understand the effect of settlements on their needs-based public benefits and know that there are solutions to help keep those benefits. Finally, we discussed that nearly all types of personal injury settlements, and certainly savings from lien resolution, can provide an opportunity for an injured party to plan for their future. That plan involves future periodic payments versus a lump sum of cash at time of settlement. The decision to use one or more of the settlement planning options depends on each injured party's situation. By partnering with Synergy, an attorney can have confidence that the injured party will not only receive every penny they deserve through lien resolution, but also that they have the solutions to preserve and protect their recovery. For the injured party, there is a dedicated team of professionals that can take on difficult issues such as lien resolution, Medicare compliance, public benefit preservation, and complex settlement planning techniques, expert advice, and sound planning help ensure that long-term needs are met.